Hello, this is attorney Shellon Washington, owner and founder of the Washington Law Firm located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100. Good afternoon, guys, and welcome to today's discussion, the law and you. I encourage you guys to share the link. On this program, we'll be discussing various aspects of the law and how it affects you, whether you be in New York or in Ghana. For the most of this broadcast, we'll be focusing on various aspects of the law. Today, we'll be focusing on divorces. And if you know a family friend or anyone who might be going through a divorce or contemplating a divorce, this might be of interest, particularly for that person. And if there's any particular legal issue that you would like to hear on this program, you can share your thoughts with me and I will discuss it. Or if I'm not an expert on that area, I will be sure to bring one of my colleagues who are an expert in that area. So I encourage you, go ahead and share the link and send to your friends, your family, have them join this discussion so I could provide you with valuable information that you can use to help you to be successful as it relates to legal issues you might encounter if you live in New York or if you live in Ghana. Go ahead, share the link. I'm hoping that we get more people get on the live so that we can get it going and discuss the issue of contested and non-contested divorces in New York. And some of that might affect you if you are from Guyana, and we'll discuss how the two interrelate and the one affects the other. Go ahead, share the live now, share the link, get everyone on so we can get right into the discussion. This is a 30 minutes program, so it's going to be very short and sweet so you can get all the information that you need. If you or a family member or a friend or anyone is facing any of these issues, and I do take questions on this aspect on this program. So if you type your questions, I will be seeing it and I will be able to respond to your comments. Okay. Today we're going to be discussing divorces, no-fault divorces. Before I get into the no-fault divorces, I'm going to give you the aspect of the domestic relations law in New York that affects no-fault divorces. I would encourage you to continue to share the link, and then let's get into it. Okay. So let's do this. I know a lot of people living in New York, they tend to go to what is called a divorce center or a document preparation center when they want to get a no-fault divorce. And a no-fault divorce, so just so you understand, you can do a no-fault divorce yourself, because I understand it's low cost, it's not a lot of money, and I'm seeing Bentley Edwards is saying $700 in child support. He's asking about child support. We'll get to the child support, but let's talk about the divorce aspect of it first. Now, the uncontested divorce is more important if you are married. People get married for various reasons. People get married for, they come to this country, they get into a relationship with somebody, and it might be a situation where that person is going to help them to get a green card, or it might be for some other reason. They get into a marriage and then they realize the marriage is not working and they want to get out. Well, I got good news for you, because in New York, there's what we call no-fault divorce. You can quickly just divorce the person. Previously, you had to have a ground, like it had to be like cruelty, desertion, adultery. There are a number of other grounds that, was used prior to the no-fault ground. So now we have the domestic relations law, which was amended to allow for divorces where there's no fault. There's just simply an irretrievable breakdown in the relationship between the parties, and that's DRL 177. Okay, so if you have a no-fault divorce, you're going to be getting that under the DRL 17 in parentheses 7. That's the grounds. That's a section on the domestic relations law that you're going to be looking at if you would like to get divorced and get out of a relationship that you're in right now and it's not working out and you don't have any children. If you don't have any children, it makes it easy. No minor children, or there are no assets between the two parties. So it's relatively short marriage. Both parties have equal amount of income, and or the income is not that far apart, so that there'll be any issue to be contested that one party might need maintenance or spousal support and the other may not. So if it's just a relatively straightforward divorce, there is the DRL 170. 7. This is no fault divorce in New York. And under this section, you could literally, like I said, apply to the court. Just go to one of those document centers we talk about, have the paperwork prepared and have it filed with the court, asking the court to grant you a divorce. The court is very lenient when dealing with what is called pro se litigant. So you would be considered a pro se litigant, meaning you want to represent yourself because you just need a divorce quickly and get out of the court. Now, if there are any complex issues involved, you cannot do it pro se. For instance, if you have a house, if you have assets, money in the bank, cars, land in Guyana, land in New York, and you have retirement accounts, pension, 401k, IRA, RAT, any of those deferred compensation, any of those types of assets would now put you in a precarious situation where either you need to protect the asset or you got to split the asset with your spouse. A lot of people prior to getting married, if they have assets, they do not consider like, what's going to happen if you get married before. What's going to happen if you get married after you already acquired all these assets? What's going to be the end result? A lot of people don't consider that, you may need a prenuptial prior to getting into a marriage. So a lot of people just jump into relationships and they have all these assets and they expose themselves now to the possibility that if the marriage doesn't work out, you have to divide your asset and give to your spouse something that you acquired. And a lot of people come with the misconception that, hey, I had this before I married this person, so they're not entitled to any of it. But it's not necessarily true. You have to look to see whether or not during the marriage, you took any of your marital assets and contributed to those pre-acquired assets. So for instance, if you bought a home before you got married to somebody, you moved into the house together, you're still working, your spouse is working, and then there's a leak in the roof. And then your spouse say, hey, look, I have $5,000, I'll contribute. And then you contribute the other $10,000 towards repairing the roof. That makes the property, part of the property now, marital assets, because you use marital asset to contribute towards improving a pre-marital asset. So now you put yourself in some amount of trouble because now your premarital asset is commingled with marital asset. So if you have assets, it's never a good idea to go to the divorce center and try to do a pro se divorce. You will need to consult an attorney who will advise you as to what you might need to do and what aspect of your asset might belong to the marriage and what portion of it will not belong to the marriage. So I encourage you, if you do have assets, do not go to the divorce center. Just pick up your phone, give my office a call or any divorce attorney a call and have that aspect sorted out prior to filing the divorce, because you might need what is called a stipulation of settlement. You might need to enter into a settlement with that person prior to getting a divorce. And just so you know, all aspects of any type of settlement assets must be addressed prior to you getting a divorce from your spouse. So if it's a case where a lot of times in Guyana, we have what is called housewives. Over here, they are wives who are called stay-at-home mother, and they stay home and they care for the children. They take care of the children. And at the end of that, if the marriage doesn't work out, a lot of times, coming from Guyana, Guyanese men would, say they don't want to take care of the woman if they're not with the woman. But that doesn't happen here in the United States. Those people are protected by laws. So if you choose to take a woman who is incapable of being self-supporting and you marry her, and then you decide, I'm going to be divorcing her, you will be responsible for taking care of that woman up to the point where she might become self-supporting. And there's limitations to that, obviously. The court look at several factors to determine whether or not you should be responsible for that woman, including whether or not she has a degree, a college degree, or whether or not she has the ability to go back to school and make herself self-supporting. And I know several instances of this, I guess, because I'm, in addition to being an attorney, I'm also around the church a lot because I'm a pastor also. And I've seen situations where people went back home to Ghana or to Trinidad or to wherever they're from, and they marry a spouse and bring the person here. I even know a situation where one person, being of Guyanese descent, went to a different country, married a woman, and brought the woman here to the United States to live with him. Now, if you should choose to bring somebody to live with you, and that the person comes here and they have absolutely no work experience or skills, marketable skills that they can go out there and have a job, the law says you will be responsible for that person if you choose to divorce that person. So if afterwards you realize it's not working out, I need a divorce, I need this person to go their separate ways, I'm going to go ahead and go get a divorce. You need to consult an attorney and not rush to do this on your own, because there's several factors that needs to be considered prior to filing that divorce. And then you yourself would have to sit down and determine whether or not it's economically feasible for you to move forward with that divorce, especially if there are minor children involved. Which brings me to the next issue as it relates to children and divorces. Now, if you are trying to get a divorce, you have minor children, again, I would encourage you not to go to the divorce center, but to consult an attorney. I would encourage you, pick up your phone, call my office, get information before you rush to do that. If there are minor children in a marriage, then, you know, the issue of child support and the issue of which spouse will be the custodial parent or for residential purposes, because there's two different types of custody. There's actual legal custody, and then there's physical custody. And then the issue of determining who is going to keep that child is a really important factor that you need to consider prior to filing your divorce. While the parties are living in the same house, the issue of custody is not a problem. But once you decide, hey, I would like to file a divorce and I would like to live in a separate property from where my spouse is living, then that becomes a factor. You have to consider it and determine how and when, you know, who is going to keep the children or child, and then who is going to be responsible for paying child support. Now, obviously, the parent with physical custody is the parent who will be receiving child support. The parent who doesn't have custody, physical custody, but maybe merely have legal custody, that's the one who's going to be paid, the payer. They're going to be paying child support to the parent who has physical custody of the children. And I did see earlier on, when I just came on, somebody was saying, they were talking about, I'm looking at the comment right now. He said he went to an uncontested divorce and his wife was asking for $700 monthly for child support, but his children currently living with him. You know, that cannot actually happen, because first of all, if you go through an uncontested divorce, the court will make sure that in the judgment of divorce, somebody has custody of the children, because a divorce judgment is not supposed to be granted unless all ancillary issues are dealt with. And this is why I encourage people, do not run for an uncontested divorce when you have children involved, when you have property involved. That's a wrong deal, because once you do that, that judgment is going to stand. And if you want to undo that, you have to go back to the court, vacate the judgment, and have the proper thing, or have it done correctly. Or alternatively, you have to go to the family court and ask that you be granted full custody of the children. And I think a lot of times with the uncontested divorce, some people, they don't even put that they have children. And if they lie and say, well, I don't have children, then that's the result. The court is going to grant you your judgment, but then there's not going to be any resolution on child custody or child support. So in this case, where Bentley's talking about having the children, I would definitely want to take a look at the judgment of divorce, because the judgment of divorce is what tells you what is the final resolution between regarding all aspects of the divorce between the parties. If they're children, the judgment must tell you who has custody and who is going to be receiving child support and how much that child support is going to be. And in addition to that, the judgment is the thing that also tells you what happens to your pension, what happens to the other party's pension, what happened to the house, if there is any. And if there's no such reference on the judgment of divorce, then you're in trouble, especially if those children were already born at the time you got the judgment of divorce. If the wife was pregnant at the time, then, you know, different factors obviously comes into play, and you wouldn't deal with the issue of custody at that time. You have to wait until the child is born. So if the judgment is granted before the birth of the child, then you have to go to the family court and make an application for custody. Now, the family court has concurrent jurisdiction with the Supreme Court in this country. Neither of them is superior to the other. They're both concurrent jurisdiction. Now, if you have this sort of problem where you have an uncontested divorce, and then you have to, your wife is asking for, your ex-wife, I shouldn't say wife, your ex-wife is asking for $700 monthly, or if you're still going through the divorce, because what it looks like, he says his wife filed for custody. Okay, so if your wife went ahead and she filed for custody, you could make a cross application for custody also. You could make the same application, but the judgment is where that is usually dealt with. You know, in the divorce aspect of it, you can even turn your uncontested case or have the uncontested divorce most likely turn into a contested divorce. If it's not concluded as yet, that would be the most prudent thing to do. Otherwise, you'll be in two separate courts fighting for children in the family court and custody and child support, and then dealing with the divorce in the Supreme Court, which makes absolutely no sense. It's a waste of your resources, waste of your finances, waste of your time. You'll be running back and forth to two different courts. You don't need that. So if you have a case where the wife is trying to get the custody, and once it's being done, that most likely, if you're negotiating in the uncontested divorce matter, this could be resolved before you get the judgment in the uncontested divorce matter. But in a situation like this, I would definitely encourage you, if you can settle it outside of the court, settle it first. If you're unable to settle it, then you take the uncontested divorce and turn it into something that is contested. Now, $700, I would not know whether or not it meets the standard based on the Child Support Standard Act. Now, it's based on your income, just so you know. It's 17% of your income if there's just one child. And it changes based on the number of children that, you know, they're applying for child support for. So I'm not sure how many children you have, Bentley, but if I knew that, and then I knew what your income was, and he's saying it's a bi-weekly amount, but you will have to check your income first of all, and you have to do the math. No, you take out, it's two deductions need to be done on your income. They don't take out the state nor the city, nor the state nor the federal taxes, but they take out your Medicare, your FICA from your income and deduct the local taxes, the city taxes, and whatever is left. He said it's two kids. You divide whatever is left of that income, you multiply it by, for one child, like I said, it's 17% for one child. And that number changes based on the number of kids that you're asking the court to grant child support for. Now, even though I know how many kids you have, I still won't be able to tell you exactly the amount of child support that you will be required to pay and whether or not that amount is correctly calculated. But I will tell you there is a calculator located on the Supreme Court website, which you can go and just Google Supreme Court Child Support Calculator, and you can pull that calculator up, enter your numbers in, only the numbers for you, and you'll be able to see how much exactly you will be on the hook to pay for child support as it relates to both of your children. Okay, so you have to do the necessary deductions, and then you multiply by that number. I believe for two children, it's 25%. So you multiply it by that percentage, and you'll get the amount that you're required to pay biweekly. I don't know whether the 700 is correct or fair, as I said, because it's income based. It's restricted to a person's income. So therefore, you would have to be able to tell me exactly what your income is prior to me being able to tell you that. Now, I'm going to take a quick break for a commercial, and I will be right back to wrap it up in the next 10 minutes. This is The Law and You, and thank you for being here, and I hope that you will continue to share the like. We'll take a quick commercial break at this time. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100. Welcome back, guys, and thank you for staying here with me this afternoon for The Law and You. And like I said, from time to time, we will be discussing various legal issues affecting you. We're hoping next week we will be discussing traffic issues, minor traffic infractions in the state of New York next week. So every week, I want you guys to join me. I'll try to be here at the same time, 4 p.m. every week, and we'll discuss different legal issues that are affecting you, including traffic offenses, which is something I do not practice, but I do have a lot of colleagues that practice that, criminal law issues, immigration issues, divorce issues, which is what I'm discussing right now. And, you know, from time to time, I'll discuss child support issues, alimony or spousal support issues, which a lot of people are affected by. And that's the thing, people need to understand that whenever you're marrying in the United States, it's best to marry your equal. If you're not marrying your equal, you could jeopardize yourself or put yourself at risk of having to pay your spouse if at some point the divorce don't work out. And you know, I've had instances where people were placed on spousal support for a very, very long time. It could be indefinite. The average time for spousal support in the state of New York is about 3 years, but it varies on the circumstances, the length of the marriage, the ability of the spouse to be self-supporting. Because obviously, if there's a marriage that was there for, like, let's say 30 years, you know, it's very difficult for if you marry somebody 30 years and that person never worked a day in their lives, and you are the one taking care of the home, paying the mortgage or the rent, putting food on the table, supporting the children. At the end of that, if you decide that you're going to divorce that spouse, it will be almost impossible for you to walk free without having to take care of that spouse. You may be on the hook for spousal support, whether it be a male or female. A lot of people are shocked when they come to America and they realize that women do pay spousal support also. It's not just men. So if a woman chooses to be, let's say the woman is a doctor or a nurse, and she chooses to marry a stay-at-home father, she is going to be on the hook for taking care of that man if the marriage does not work out. And let's say he has no marketable skills that he'll be able to go out in the working world. And let's, for argument's sake, say the marriage lasted let's say it lasted for 15 or 20 years. The longer the marriage, the greater your probability of supporting that person for a considerably lengthy period. And in order to avoid it, the quickest, easiest way to avoid these things, people, is what is called a prenuptial. And I know a lot of West Indian people and Caribbean people don't even think about prenuptials, but a prenup is really, really good, and it's really important that you should seek that out if you have any assets. And you would like to protect that asset against any future possibility of getting into a divorce. Yeah, so I see, yes, bench operator, women do pay for stay-at-home fathers too. So it's just not just women, it's not just men have to pay women, but it goes both ways, especially in this country. This country tries to keep a balanced situation where the person doesn't become a ward on the state. The state tries to avoid having a situation where a spouse becomes dependent on the state and then they have to support the state has to support that spouse now, because they get on Medicaid, because then they get the divorce, and the income that they were used to in the marriage and the lifestyle, they lose that. And that's why the domestic relations law protect those spouses from the possibility of them becoming a ward of the state. State doesn't want to take care of your spouse. That's your responsibility. You took that person and married them knowing that they had no skills. They had no marketable skills to go out there in the working world and find a job. So if the marriage fails, guess what? Your pocket is going to fail too, because now you're going to have to be stuck with supporting that person. And people just understand that men do get custody also. There's several factors that the court takes into account if the court is to award custody to a man. So in the case of the person I was referencing earlier, just so you know, if you wanted custody too, there's a possibility that you can apply and be given custody if you reach the requirement, because the court looks at the best interest of the child principle. And somebody said men are getting wise now. They're marrying into money. And when it breaks down, they seek financial support. I mean, Carl Miller, you're correct, because that has been happening. We know a famous case, Mary J. Blige, where she was required to pay her ex-husband, and she still continues to this day to pay her ex-husband. So we know that these are things that happens. And we know the famous Wendy Williams also was trapped in the same situation, where she was working for more money and her husband was the manager and he was working for less money. And at the time they filed for the divorce, she was on the hook to pay spousal support to her ex-husband. So we understand that this thing goes both ways, and it's most important that both sides should seek to protect themselves by getting a prenuptial. It's rare I see a Guyanese person walk in and say, well, I need a prenup to protect myself in the event that this marriage doesn't work out. So I think most Caribbean people need to start thinking about prenuptial seriously, especially if you're going to think about going back to Guyana and marry your spouse, or going back to your home country, wherever you're from, and marrying your spouse and bringing your spouse to New York to live with you. You need to consider the possibility that you may need to protect yourself before you get married. And don't worry, even if you get married, you can do a postnuptial also to protect whatever assets you have, if the party is willing to sign a postnuptial. Otherwise, you're stuck. You're stuck with a situation if you're the money spouse, and you're called the money spouse if you're the one working for a significantly higher amount of money than your partner, or you're the only breadwinner in the home. You are referenced to as the money spouse. So just so you bear this in mind, that if you marry someone and you're the breadwinner in the home, you could be stuck with paying child support and spousal maintenance. These are the two things you could be stuck with. Okay, so I see Brenda saying she's not getting married again. Too much stress with these men. I think, Brenda, it's stress both ways. It's not just based on one side, because there are women also who do the same thing to men, and there are men likewise who do the same thing to women. Somebody saying no prenups exist in UK. That's sad if UK doesn't have prenup. Fortunately for us here in America, we do have prenuptials. You can enter into a prenuptial, or even if the marriage should go south, it should go bad, you could enter what is called a separation agreement during the marriage. You and your partner could sit down and work out the details of a separation agreement, but the separation agreement must be properly notarized, and you could file it with the court, and it can remain there until you're ready to file for your divorce. So that's your final option, either prenup, postnup, or a separation agreement, if both parties decide that they're going to go their separate ways. With a separation agreement, you could then move forward and file an uncontested divorce. So guys, we have come to the end of this program. It's now 4:29. We're almost at 4:30. It's a half an hour program where we discuss various issues or various aspects of the law that affects you if you live in Guyana or you live in the state of New York. Okay, so we have come to the end. We have come to the end of this program. Thank you so much for staying here, for sharing the link, for your comments. I hope I've answered some of the questions that you have. You can come again next week with your questions. I will be joining you next week with my colleague. His name is James Williamson, and we will be discussing various aspects of traffic offenses or traffic infractions. So I will see you again next week as we discuss current legal issues that affects you with the law and you. Once again, guys, thank you so much for being a part of my audience and listening in and sharing the link and liking this program. And with your help of sharing the link every week, we will be able to continue to provide you with valuable legal information. It's not legal advice, but it's information that you may need to help you to function in terms of any legal issue you may face from time to time in New York, or sometimes we'll discuss issues in Guyana. Thank you for listening in, and good afternoon, and do enjoy the rest of your weekend. Thank you, guys. Thank you. So this is attorney Shellon Washington, owner and founder of the Washington Law Firm, located at 455 Utica Avenue in Brooklyn, New York. We're specialized in medical malpractice, personal injuries, matrimonial law, and landlord and tenant. If you're in need of legal representation, please give us a call today. The number to call is 718-877-3100. Consultation is free at no cost to you. So call us today to see if we can be of any assistance to your legal needs. Again, the phone number to call us is 718-877-3100.